Good afternoon or evening, depending on where you may be in the world. Um, my name is Wendy, and I'm your host, and this is Truly Sinister. Welcome back. Today, we are going to go over the ruling for Turtle Boy and Aidan Kearney and Karen Reed's anti-Slapp motion to dismiss in their civil case against the should have been suspects slash house defendants. Judge Gildea basically put his decision for both of their motions in one writing, which they were filed as two separate motions. So I think that's kind of I don't know. I don't know if that's common or what. It just seems kind of lazy to me, but whatever. So we're going to get right into his ruling and his decision on their motions to dismiss. And then after that, we're going to go over Gretchen Voss's latest article slash story. I think she might be letting herself be misled by the should have been suspects, and she's kind of putting all of her eggs in one basket, so to speak. And I get a feeling that she didn't really vet everything that they told her or ask for receipts, because she made a lot of misstatements that I feel like she's going to have to correct publicly or possibly suffer the consequences. Yeah, that's how bad some of them are. It's just unbelievable that such a seasoned journalist would just take anybody's word for something and not vet what they're telling you. But it's obvious that's what's happened. And I think she's going to come to regret crawling into bed with the should have been suspects. I mean, it's basically what it boils down to. She's doubling down on them, siding with them instead of being impartial and just printing the story. She's trying to put a spin on things, and basically she's in the house defendant's corner, and it shows. And I think she's going to come to regret that, to be honest with you, because I don't think they were totally honest with her, and I don't think she did the responsible thing that a journalist should do, which is ask for receipts or vet what they're telling you. I mean, get both sides of the story, maybe. How about that, at least? But yeah, so that'll be interesting. So we're going to move right along, because her article is not very short. So yeah. Okay, let's see. I hope everybody's having a good weekend so far. Okay. Memorandum of Decision and Order on Defendant's Special Motions to Dismiss pursuant to the Anti-Slapp Law. Plaintiffs Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins brought this action against defendants Karen Reed and Aidan Kearney, alleging they conspired to defame them by falsely stating they were responsible for the death of Reed's boyfriend, John O'Keefe. You notice how they don't say Officer John O'Keefe? I wonder what the problem is. Why are we having such a hard time calling him Officer John O'Keefe? He was still an officer when he was killed, correct? So what's the issue here? I'm not quite sure. The first amended complaint, FAC, asserts claims against both defendants for defamation and negligent infliction of emotional stress and civil conspiracy. The plaintiffs also assert separate claims against Reed for aiding and abetting in Kearney's defamation and infliction of emotional distress, and against Kearney for violation of GLC 93A. The defendants have each filed a special motion, So why is he doing them together? Motion to dismiss the FAC pursuant to the anti-Slapp statute. For the following, footnote 3, the defendants have also each filed motions to dismiss pursuant to Mass R Civil 12B6. Those motions will be addressed in a separate decision. Well, thank you. For the following reasons, the motions are denied. So we saw that coming. Discussion. The anti-Slapp statute establishes a procedure for obtaining the early dismissal of a claim that seeks to impose liability on individuals for exercising their constitutional right to petition. These powerful procedural protections were intended to be employed in a limited context to ensure the expeditious elimination of meritless lawsuits based on petitioning activities alone. However, the statute has been regularly invoked in attempts to dismiss a wide array of other claims concerning conduct far afield of the petitioning activity that legislature originally sought to protect. No, it's actually a very broad law. To ensure that a special motion opponent's own petitioning activity is not infringed by the allowance of a special motion to dismiss, the Supreme Judicial Court, SJC, has adopted a two-stage burden-shifting framework for analyzing the merits of a special motion to dismiss filed under 231 and 559H. To prevent these special motions to dismiss and the powerful procedural protections they afford to litigants from being misused to quell petitioning activity, our jurisprudence has adopted a necessarily narrow and strict construction of the statute. Well, that's the first time I've ever heard that it is narrow and strictly constricted, because everybody that I've heard talk about it says how broad the anti-Slapp is. A party seeking dismissal under the anti-Slapp statute must make a threshold showing through the pleadings and affidavits that the claims against it are based on the party's petitioning activities alone and have no substantial basis other than or in addition to the petitioning activities. If the special motion proponent cannot make this threshold showing, the motion this threshold. Okay, let's start over. If the special motion proponent cannot make this threshold showing, the motion is denied and the challenged claim survives. However, if the special motion, I'm having a hard time, proponent is able to make the threshold showing, the motion will be allowed unless the non-moving party demonstrates that the petitioning activity was devoid of any reasonable factual support or any arguable basis of law. and cause the unmoving party actual injury. So I think we can all agree that they don't suffer any actual injuries. I mean, they're doing their fair share of taunting Aidan Kearney. So I don't think they're that intimidated, and I don't think they're that emotionally distressed to go on taunting him and addressing him like they do. As noted, the defendants have separately filed special motions to dismiss under the anti-Slapp statute, and therefore they each have the initial burden of showing that the claims against them are based on their petitioning activities alone and have no substantial basis other than or in addition to those petitioning activities. Petitioning activity under 59H is 1. Any written or oral statement made before or submitted to a legislative, executive, or judicial body or any other governmental proceeding. Any written or oral statement made in connection with an issue under consideration or review by a legislative, executive, or judicial body or any other governmental proceeding. 3. Any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body or any other governmental proceeding. 4. Any statement reasonably likely to enlist public participation in an effort to effect such consideration, which that's his big one right there, because that's exactly what they are describing him of doing. Or 5. Any other statement falling within the constitutional protection of the right to petition government. The court concludes that neither defendant has made the threshold showing under the statute. I have to disagree with that. Defendant Kearney's initial burden. The plaintiffs assert claims against Kearney for defamation, intentional and negligent infliction of emotional distress, civil conspiracy, and violation of 93A. As explained below, Kearney has failed to satisfy his initial burden for 2 reasons. First, the claims have a substantial basis other than petitioning activity. And what would that be? Second, even if this were not the case, the FAC alleges that he was not engaging in petitioning activity on his own behalf, but rather on the behalf of Reed. So what? Does anti-Slapp state that you have to be petitioning on your own behalf? I don't think it does, right? It makes no sense. A. Other substantial basis. Kearney argues that the plaintiff's claims seek to hold him liable for petitioning activity because his statements fall under the 2nd, 3rd, and 4th clauses of 59H. However, he has failed to establish that this is the case. 1. Defamation claim. The defamation claim is primarily based on Kearney's repeated statements accusing the plaintiffs of murdering O'Keefe and covering it up. Kearney argues that by publicly accusing the plaintiffs of murder, his statements were reasonably likely to encourage consideration of a review. Well, that's what he was trying to do. As long as he believed in it. And I think anybody that watches any of Aidan Kearney's videos on YouTube in regards to the Kearney case can verify that he truly believes what he's saying, as well as a lot of people. Reasonably likely to encourage consideration or review of O'Keefe's death by an executive body. However, of all the various places Kearney made these statements, on his live stream, social media platforms, his blog, on plaintiffs' voicemails, at the plaintiffs' homes, and in the case of McCabe at her daughter's lacrosse game, none were to an executive body. So he has to speak directly to the court or the DA's office or the police officers in order for it to be considered a petitioning activity as part of a judicial or other proceeding or to any authority that could affect consideration of the issue. Filing of a complaint for an abuse protection order and the submission of supporting affidavits are petitioning activities. He didn't need a protection order at that time. So, I mean, defendants' appeals to the police and to the courts were quintessential petitioning activity. Reporting suspected criminal activity to the police was petitioning activity. Kearney cites no case law suggesting that statements to other members of the public accusing someone of murder qualify under this clause of the anti-Slapp statute. Such statements lack the characteristic of petitioning activity under this clause. So he has to actually go in and file a police report that he believes these people are guilty of John O'Keefe's murder and then show that as proof in order for it to be considered under the anti-Slapp law? Really? Kearney next argues his statements are petitioning activity because they were made in connection with an issue under consideration or review by a legislative, executive, or judicial body, namely the investigation into O'Keefe's death and the prosecution of Kearney. The SJC has stated that for statements to qualify under this clause of the anti-Slapp statute, there must be a plausible nexus between the statement and the governmental proceeding. In the stated case, overruled on other grounds by Bristol, Mass. Quote, to assess if this plausible nexus exists, the SJC analyzes objective indicia of a party's intent to influence a governmental proceeding, end quote, such as the timing, audience, and content of the statement. The communications must be closely and rationally related to the governmental proceedings. I think they were. Hence, they were out in front of the courthouse petitioning. And made to influence, inform, or at the very least, reach governmental bodies, either directly or indirectly. Okay. Well, Judge Kearney was making some rulings in regards to his petitioning activity. So obviously they influenced and informed the court, which is a governing body, right? Oh, lordy. Although some of Kearney's statements, at least tangentially relate to an issue that was under judicial review, the prosecution of Kearney, for example, the prosecution of Kearney, the claims largely target statements that do not have a plausible nexus to this prosecution. The statements are directed toward viewers and potential viewers of Kearney's live stream and readers of his blog, and their content does not seek to influence government action in any way. Well, that's funny because I specifically remember Hank Brennan referring to quite a few of Turtle Boy YouTube videos, as well as Mello and anybody else. So they are reaching the governmental body. That's a complete lie. Posts not directed to the government, and that did not mention any government proceeding, but rather consisted of throwing barbs at another, was not petitioning activity. Rather, the statements are aimed at convincing Kearney's audience to regard and treat the plaintiffs as the murderers. He was giving them the facts and giving them the opportunity to weigh the facts and make their own decisions. It is what it is. Jennifer McCabe and Brian Albert are involved. They are covering it up. The McCabe's have the look of evil in them when you see them in person. These are people with no shame and aren't the least bit deterred by the fact that millions of people know that they participated in a murder and subsequent cover-up of a murder of a Boston police officer. Jen and Matt McCabe do not deserve to live a normal life and pretend that they weren't involved in murdering a Boston police officer. Such statements are markedly different than those that courts have concluded are, quote, made in connection with a proceeding under judicial or executive review. Statements to media by firefighter's widow, Wynn v. Craigle, where statements to media by the firefighter's widow were sufficiently tied to and in advancement of her petition for benefits under consideration by the legislature and were mirror images of what she had reported to the government body. The FAC also cites allegedly defamatory statements Kearney made after the second trial had ended and therefore not connected to any issue under judicial review. That's not true because they had already filed the civil case against Karen Reed, the wrongful death case against Karen Reed. So he most definitely had a judicial review going on, because that one was just getting started in the court system. Wow. Settlement demand made to resolve disputed issue under review by planning board was made in connection with pending governmental proceedings. Quote, that Kearney's statements concern a topic that has attracted governmental attention in itself does not give them the character contemplated by the statute. Who says? Who gets to decide that? Finally, Kearney relies heavily on his argument that his statements were reasonably likely to enlist public participation in an effort to effect consideration by an executive or judicial body. In this motion, he cites multiple instances where he both encouraged people to demand answers from the MSP and Norfolk District Attorney's Office and encouraged his audience to engage in standouts and to gather at the courthouse in protest of the prosecution. While the court agrees with Kearney that such conduct constitutes petitioning, okay, I've missed a footnote. Footnote 4. To the extent Kearney contends that his post-verdict statements were likely to encourage review by law enforcement and into those responsible for O'Keefe's death, allegations in the FAC belie his claim. For instance, the FAC cites Kearney's communication to his followers to use a code for the McGalberts killed John O'Keefe. FAC at para 14. I think that means paragraph or 141. It strains credulity to argue that such a statement, which obscures the message so only his followers can understand it, could reasonably be interpreted as made to influence, inform, or reach government bodies. The FAC also alleges that Kearney posted a video encouraging his followers to attend and protest a fundraiser hosted by a supporter of the plaintiffs, asserting that it was being held for the people that framed Karen Reed for murder and that they killed John O'Keefe. It is unclear how encouraging his followers to attend a private event would be reasonably likely to encourage review of O'Keefe's death by an executive body. I don't remember. I watched all his Canton cover-up episodes, and I don't remember him ever telling anybody to go to that event. So, I don't know. While the court agrees with Kearney that such conduct constitutes petitioning activity, his argument that the statements cited in the FAC are related to this conduct and are therefore should be viewed similarly is without. The fact that defendant's initial post constituted petitioning activity did not then throw an anti-Slapp protective blanket over every post that followed. The defamation claim is not aimed at the specific instances that Kearney cites in his motion. Rather, the claim encompasses statements that are far removed from any call to the public to appeal to the government, namely the many instances where Kearney accused the plaintiffs of murdering O'Keefe and covering up their crime by addressing them directly at their homes via his live stream, or in the case of McCabe at her daughter's lacrosse game. In those statements, Kearney neither explicitly nor implicitly calls on his audience to implore anything to a governmental body. Number 5. For instance, Kearney does not explain how his enlistment of 200 individuals to participate in a rolling rally to go to the plaintiffs' homes while he shouted into a bullhorn that Brian Albert and McCabe were covering up John O'Keefe's murder was reasonably likely to enlist public participation in an effort to effect consideration by an executive or judicial body. Nor does he address how going to McCabe's daughter's lacrosse game and calling her a cop killer was likely to do so. Although neighbors' opposition to home renovation before town boards was protected, a threat made as the neighbors were leaving a hearing before the board was not protected. He never threatened anybody. Simply filming his actions and posting them later does not bring such conduct under the protections of the anti-Slapp statute. Okay. To be sure, the FAC cites many statements that were reasonably likely to enlist Kearney's audience to share his opinion and to make that opinion known to the plaintiffs and other members of the public. See e.g. FAC at para 19, citing Kearney's statements that he has nothing but hatred for Plaintiff McCabe, as I should because I'm normal. I'm a rational person. Any rational person hates Jennifer McCabe and is disgusted by her because Jennifer McCabe is a pig. She is a pig. She's a cop-killing pig, end quote. Responding to claim by McCabe's friend that she was harassed by Kearney's supporters in public, Kearney stated, "The fact that Jennifer McCabe has to cover her face in public like this because everywhere she goes, people immediately see her face and recognize her as a cop killer is a great thing." That's his opinion. He's entitled to it. Alleging Kearney addressed his audience members who had not confronted the plaintiffs, stating, "They're right fucking there, walking around like nothing happened. What are you going to do about it, huh? You going to ask them anything? You going to talk to them? You're not in this for being uncomfortable or making people who committed horrific crimes uncomfortable." Okay, now that statement is being taken out of context because I believe that was on either his Tuesday Night Live or Saturday show where he was talking to other YouTube creators about why they didn't step up and speak up for Karen Reed when Kate Peter uh, verbally attacked her outside the courtroom. Remember that? Kate Peter went off on Karen Reed outside the courtroom, and everybody was talking about it, but nobody spoke up for Karen Reed. And he was calling on them. And why don't they make, they're not meant to be comfortable. They need to call these people out on what they're doing. That's who he was talking to. He wasn't trying to get his followers to make Jen McCabe feel uncomfortable. Just one second. I don't Judge Gildea watched any of these hyperlinks. I honestly don't. Because he's taking everything out of context just like they did. However, for such statements to be protected petitioning activity, they must be reasonably likely to enlist public participation in an effort to affect, i.e., bring about governmental consideration of an issue. See Doe v. Thorell. The statements that are the subject of the defamation claim clearly are not. Anti-SLAPP law does not protect tangential statements intended at most to influence public opinion in a general way unrelated to government involvement. So you can only try to influence and sway public opinion when it has something to do with the government? Huh. I feel like that's not true. Website. Okay, see also Cato Company v. Schlickman. Website designed to disseminate to the public information about plaintiffs to attract clients to defendants' law practice was not reasonably likely to enlist public participation in an effort to affect such consideration. 2 other claims. Kearney's motion as to the plaintiff's other claims for intentional and negligent infliction of emotional distress, civil conspiracy, and Chapter 93A similarly fails because the claims are clearly not based solely on petitioning activity. These claims go beyond Kearney's statements calling the plaintiffs murderers, which, as explained above, are themselves primarily not petitioning activity, and seek redress for his actions in purportedly organizing the rolling rally mentioned above, publicly releasing the plaintiff's personal identifying information, harassing the plaintiffs and their family members, and encouraging others to do the same. Conspiring with Reed to cover up her crime by wrongfully accusing the plaintiffs and operating a commercial enterprise selling merchandise featuring the plaintiffs' names and likeness. As to these claims, Kearney also has clearly not satisfied his initial burden, and therefore the motion must be denied. B. Petitioning in one's own right. Even if Kearney's conduct that is the subject of the challenged claims could be considered petitioning activity, his motion fails for an additional reason. The anti-SLAPP statute provides that a special motion may be brought for claims against a party that, quote, are based on said party's exercise of its right to petition under the Constitution, end quote. That phrase is read, quote, as restricting the statute's coverage to those defendants who petition the government on their own behalf. I don't think that's what it says. Oops. I don't think that's what it says, though. That may be how you read it, but I don't think that's what it says. The statute is designed to protect overtures to the government by parties petitioning in their status as citizens. ID. Although the party bringing the special motion, quote, need not be the beneficiary of the particular cause the party seeks to advance, end quote, protections of the statute are limited to those who, quote, engage in petitioning activity in their own right. Here, the FAC alleges that Kearney was not speaking on his own behalf, but rather on behalf of Karen Reed. The FAC alleges that Reed found and enlisted Kearney to publicize a story about the plaintiffs, and that Kearney agreed to and did publicize and widely disseminate Reed's false claims, as he's no, they're false. She was found not guilty about the plaintiffs in an effort to destroy the reputations of these individuals, so that Reed could evade responsibility for causing John O'Keefe's death. Well, she didn't need to evade responsibility because he was found to not have been hit by a car. Therefore, a car did not hit John O'Keefe, and John O'Keefe did not hit a car. So if he was not killed by Karen Reed, the only other option is he was killed by somebody in that house. Those are your only two options. And one of them's taken away. So what? Unbelievable. Wow. It further alleges that Kearney acted on behalf of Reed in publishing defamatory statements about the plaintiffs to assist Reed in her trial, and that Kearney used information in his blog posts which Reed funneled to him with knowledge that he would publish it on her behalf. It is not illegal for a defendant to speak to the media. They just don't usually do it. But she knew she was innocent. She needed somebody to get that out. Nobody was listening. Nobody was covering the story. In stark contrast to the allegations in the FAC, Kearney characterizes his statements as an effort to raise awareness about police corruption, which he contends is his long-standing cause. He argues that much like the defendants in Kearney Chemrisk LLC, he was petitioning on his own behalf as an activist and a citizen. In that case, the SJC concluded that environmentalists sued for defamation based on statements made in the Huffington Post criticizing a scientific consulting firm that purportedly defended polluters were engaging in petitioning activity because they expressed their own opinions, were speaking for themselves, and at their own behest. Kearney's comparison to the defendants in Kearney Chemrisk LLC misses the mark. The statements that are the subject of the plaintiff's claims in this case have nothing to do with police corruption. The FAC does not seek to hold Kearney liable for accusing public officials of a corrupt failure to investigate the plaintiffs for the killing of Officer John O'Keefe. Oh, you called him Officer John O'Keefe, as Kearney contends. See Kearney's reply at 4. Rather, it cites Kearney's repeated accusations that the plaintiffs are cop killers and murderers who lied about what happened with O'Keefe. Yeah. And the cops are corrupt because they are not investigating anybody other than Karen Reed, because they are personally tied to the should have been suspects or the House defendants or Ham or however you want to refer to them. Given the content of the statements, it is more than a stretch to conclude that they were in furtherance of advancing Kearney's stated cause. Moreover, while Kearney's affidavit states that he wrote his blog posts on his own and Reed did not funnel him information, it does not refute the allegations that Reed enlisted Kearney to publicize her story and that he did so to assist her in trial. Yeah, because he felt like she was not guilty. Why wouldn't you help her? Thus, unlike the defendants in Kearney Chemrisk LLC, Kearney has not shown that he was speaking for himself and at his own behest. While the anti-Slapp statute provides now he's going to say it's very broad, statute provides very broad protection for petitioning activities. It was intended to protect the right to petition the government for the redress of grievances. That's your opinion. I thought he said it was a narrow with strict guidelines, and now he's saying it's very broad. I mean, make up your mind. Wow. Okay, start that again. While the anti-Slapp statute provides very broad protection for petitioning activities, it was intended to protect the right to petition the government for the redress of grievances guaranteed by the U.S. Constitution. Where there is no reasonable basis to conclude that Kearney's statements and conduct at issue in the plaintiff's claims were in an effort to care of harm, Kearney has not carried his threshold burden. Roman numeral 2, defendant Reed's initial burden. The plaintiffs assert claims against Reed for defamation, intentional and negligent infliction of emotional distress, for aiding and abetting in Kearney's defamation and infliction of emotional distress and civil conspiracy. Reed has failed to show that the claims are based solely on her exercise of the right to petition and have no other substantial basis. Footnote 6. The plaintiffs filed the FAC on June 5th, 2026. Reed served her motion to dismiss on June 23rd, 2026. For reasons unknown to the court, Reed's motion fails to address any newly added allegations in the FAC. Reed has attempted to use a reply memorandum to respond to the argument in the plaintiff's opposition that she neglected to account for many statements in the FAC. However, under Superior Court Rule 9A, a reply memorandum is limited to the moving party's initial memorandum. Emphasis added. Reed clearly should have anticipated that the opposition would have addressed the neglected factual allegations. Nevertheless, the court has considered her argument in the reply brief and finds it unpersuasive. Imagine that. Just 1 second, I need to blow my nose. Okay, I accidentally quit sharing my screen, so now I got to go back and share my screen again. Sorry. Okay. A, defamation claim. Reed's motion cites a handful of allegedly false statements she made about the plaintiffs, which she contends form the basis of the defamation claim and fall under all 5 categories of petitioning activity under 59H. Her motion, however, neglects to address many allegedly defamatory statements which form a substantial basis of the plaintiff's defamation claim and which cannot be characterized as petitioning activity. For instance, the FAC alleges during Reed's first trial, she had a documentary filmmaker, Terry Muir, record the trial preparation, which included conducting recorded interviews with Reed over the course of the trial. During an April 30th, 2024 interview, Reed stated that, quote, Jen McCabe is a first-degree murderer and she knows it, that the plaintiffs know they killed John and that the plaintiffs are murderers and they know it. The FAC also alleges that during an interview, well, they say the same thing about her, so why is it defamation for them but not her? Especially since she's been acquitted, they haven't. The FAC also alleges that during an interview on June 15, 2024, Reed told Muir and her team that Brian Higgins, Brian Albert, Colin Albert had a motive to kill O'Keefe, and that during another interview on June 22nd, 2024, Reed told the filmmakers, quote, I know Brian Higgins had a role in helping him get in the snow and help frame me. But I don't think Higgins necessarily would have wanted to really hurt John. I think Brian Albert and Colin Albert would have enjoyed roughing John up, end quote. Although Reed did not address her statements to Muir in her special motion, her reply brief argues that they fell under the second, third, and fourth clauses. However, she has failed to establish this is the case. As explained above, for statements to be reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body, they must be directed at an authority that could affect such consideration. The production staff of a documentary film is not such an authority. There's also no plausible something they went to court to make it known to the governing body that that's what they were going to do. Do you know how backed up the court systems would be? That is just absolutely ludicrous. I mean, what are we doing here? There's also no plausible argument that the statements Reed made to Muir and her team were reasonably likely to enlist public participation in an effort to effect such consideration. The statements were all made in the midst of Reed's first criminal trial, and in the case of the June 22nd, 2024 statements, 3 days before the jury began deliberating. Because they were part of a documentary film about the trial, Reed could not have reasonably believed that such statements would be released to the wider public until after the verdict. Reed has also not established that the statements were made in connection with an issue under consideration or review by a legislative, executive, or judicial body. She argues only that the statements fall under this clause because the judicial proceedings were ongoing and she intended to publicize that she had been framed in order to pressure the Commonwealth to drop her prosecution and instead prosecute the true perpetrators. That is literally petitioning activity. Did you hear that? Let me reread that. That is literally the meaning of petitioning activity, per what he said earlier. She argues only that the statements fall under this clause because the judicial proceedings were ongoing and she intended to publicize that she had been framed in order to pressure the Commonwealth, which is a governing body, to drop her prosecution and instead prosecute the true perpetrators. What the actual fuck? Are you kidding me? Wow. Reed reply at 3. However, the fact that she was involved in a governmental, he even calls it a governmental proceeding, does not make every tangential statement petitioning activity. Wow. He's been going on and on and on about how it's not considered petitioning activity if it's not trying to coerce or convince a governing body or judicial body to do something. As they finally point out that that's what she was doing, and now it doesn't. Now it's a tangential statement, and so it's not considered petitioning activity. Why don't we just make the rules up as we go along? Why don't you just tell me that you're anti-Turtle Boy and Karen Reed without telling me you're anti-Turtle Boy and Karen Reed? I mean, are you fucking kidding me? I'm sorry about my language, but that is so infuriating. And the proffered motive behind her speech is irrelevant at the threshold inquiry. She has failed to point to any objective indicia demonstrating that her statements to Muir were made to influence, inform, or at the very least reach governmental bodies, either directly or indirectly. Wow. B. Aiding and abetting claims. The plaintiffs assert claims against Reed for aiding and abetting Kearney's defamation and infliction of emotional distress. Reed contains that her conduct was petitioning activity because it was made in connection with an issue under consideration or review by a legislative, executive, or judicial body, and reasonably likely to enlist public participation in an effort to effect such consideration. She again fails to establish the claims that no substantial basis other than petitioning activity, that had no substantial basis other than petitioning activity. Reed's motion focuses on allegations in the FAC that she communicated to Kearney non-public information that was in court filings or that was evidence in her criminal trial. She does not explain how her providing Kearney, as opposed to the court, with a police report with the plaintiff's private addresses, phone numbers, and social security numbers on it. Petitioning activity includes any written statement made before or submitted to a judicial body. Well, what I have to say to that is, Adam Lawley, you should have redacted all of that information before you filed the papers. It's not Karen Reed's fault. Even if such communication could be considered petitioning activity, the aiding and abetting claims extend beyond these select allegations. See FAC at paragraphs 168, 191, 207. For instance, the FAC alleges that Reed found and enlisted Kearney, an aspiring internet personality with limited reach in the greater Boston area, with no journalist training, editorial standards, or oversight, who was seeking attention and money and routinely engaged in provocation and courted controversy to publish her false statements. She then told him that the plaintiffs were responsible for O'Keefe's death, and he broadcast such statements on his blog. See FAC at paragraphs 33 and 37. Reed's motion does not address how such statements have a plausible nexus to her prosecution. Indeed, the fact that Reed chose Kearney as an outlet for her statements, knowing he would convey the information in a way that would provoke and inflame his audience against the plaintiffs, suggests that the statements were not meant to influence, inform, or bring about governmental consideration of the issue. Well, you said right here that his statement is audience, and then you say that they weren't meant to influence the audience. Okay, well, isn't inflaming the audience influencing the audience? Commonwealth were likely to reach the decision makers at Department of Mental Health and members of the public wishing to weigh in on licensing decision. Oh, sorry, I skipped something. Blanchard, 477 Mass at 151. Statements to the Boston Globe, a newspaper widely circulated in Boston and throughout the Commonwealth, were likely to reach the decision makers at Department of Mental Health and members of the public wishing to weigh in on licensing decision. Nor does Reed explain how the content of her statements to Kearney, accusations that the plaintiffs murdered O'Keefe, either directly or indirectly, called on members of the public to appeal to the government on her behalf. They picketed outside the police station, the courthouse, the select board meetings. How is that not making an appeal to the government or to a governing body? They most definitely were doing that. Statements with no potential or intent to address a grievance or directly or indirectly to influence, inform, or bring about governmental consideration of the issue lack a crucial characteristic of petitioning activity. C. Other claims. The remaining claims against Reed, alleging intentional and negligent infliction of emotional distress and civil conspiracy, all have a substantial basis other than petitioning activity. The claims allege that Reed orchestrated a campaign of harassment against the plaintiffs, which included funneling information to Kearney and hiring a private investigator to confront the plaintiffs. That she and Kearney agreed on a scheme to defame, harass, abuse, and intimidate the plaintiffs. That she provided Kearney with non-public and confidential information about the plaintiffs, and that she celebrated the destruction of the plaintiffs' reputations while monetizing the publicity. That's a lot to unwrap. First of all, going to their house to ask them questions is not harassment. In fact, after Michael Proctor took the stand and was made to read his vile text messages regarding that he wrote about Miss Karen Reed, there was a female reporter that went up to him on his property and started asking him questions. And remember, his wife, Elizabeth, told her to get the fuck off their lawn. And the reporter said, "I'm not on your lawn." So why isn't she being charged with witness intimidation? Because they pick and choose who they're going to charge and why. And they have a vendetta against Karen Reed and Turtle Boy, a.k.a. Aidan Kearney. It's absolutely disgusting. And they don't even do anything to hide it. You know, they just go on like it's business as usual. This frickin' state, especially this county, is unbelievably corrupt. Whew. Not to mention what all this did to Karen Reed's reputation, right? Reed's motion does not attempt to explain how any of this conduct could be considered petitioning activity. Rather, she argues that all the claims are based on Reed's alleged defamatory statements to Kearney, which she contends were all petitioning activity. For reasons stated above, the court concludes they also are not. Because Reed has failed to show that her statements and conduct at issue in the plaintiff's claims were in an effort to petition to the government for redress of harm, she has not carried her threshold burden for an anti-Slapp motion. The court, therefore, need not proceed to the second step of the analysis, and the challenged claims will survive. Order. For the foregoing reasons, defendant Aidan Kearney's special motion to dismiss plaintiff's First Amendment complaint pursuant to the anti-Slapp law is denied. Defendant Karen Reed's special motion to dismiss pursuant to the anti-Slapp law is also denied. Love and kisses, Mark Gildea. Now, they can appeal that, apparently. So I hope that they do, because, you know, oh God, I can't remember his name. Is it Pyle? Is he the one that has that is the expert in anti-Slapp? I think it is. I think he is. And yeah, I think he's going to I think he's going to absolutely convince Aidan to appeal this decision. And I think he should. I mean, Judge Gildea, and I think that he should move to have Judge Gildea recused, because he obviously cannot be impartial where Aidan Kearney is concerned. That's my personal opinion. But he's showing more and more his bias. and it's not right. So I am going to end this stream and then start a new stream for the Gretchen Voss article, because her article is pretty long, and so I might as well just make 2 shorter streams rather than one extremely long stream. So don't forget to like and subscribe. It's free. I appreciate it. It gets me in the algorithm. Um, yeah, so I will see you in a few minutes for the next video. Thank you for joining me. I hope you enjoyed this video. Don't be afraid to leave any constructive criticism or comments regarding the stream. I'm open to suggestions if you have ways that you think I could improve. And with that, I will leave you to move on to the next video. All right. So, I guess ciao for now, because we're going to be right back, right? Okay. Bye.